Friends, this is Troy Brewer of Experiencing Real Life, heard every single day on Bible School Radio, 91.3 KDKR, Decatur, Dallas-Fort Worth, and on 91.3 KYJC Commerce.
Portions of KDKR programming do not necessarily reflect the views of this station, its management, or staff.
Prudent Money with Bob Brooks is sponsored by the Prudent Money Foundation on 91.3.
Well, if you got a great deal of debt, you're going to want to pay attention. Today we're going to take a look. Stay tuned for Prudent Money. Good afternoon. This is Bob Brooks, and you are listening to the Prudent Money Radio Show. Thank you so much for joining me today. You know I do appreciate it. Well, debt collectors are getting aggressive, and collection processes are becoming a little bit more tactical. Today, credit and debit expert Wayne Sanford is here to tell us more. Wayne, welcome to Prudent Money.
Thank you, Bob.
Let's start off with the journey of a debt that goes wrong. Talk about the steps in the process that takes a debt that was once in good standing to a debt that is in front of a judge.
Sure. Well, the first thing that everyone has to understand is there's a difference between a revolving credit card debt and then what's called an installment account. If you've ever heard that a negative account, like your credit card, can only stay on your credit report for 7 years, what is the 7-year clock? It's the charge-off date. The definition of the charge-off date is 180 days or 6 months of non-payment. Then the account gets charged off. On an installment account, which is a car, for an example, it's 120 days. So once that account goes into the charge-off status, the original creditor has numerous options they can pursue. They can sell your debt, they can try to collect on the debt, or ultimately they can just file a lawsuit against you for the debt.
So talk a little bit about the process of, the creditor sends out they do a deal with a third-party debt collector, and the debt collector tries to collect the debt, not very successful, gives it back, and then of course they have the opportunity there to sell it to a debt buyer. Tell me if there's any truth to this. It seems like the more that debt gets sold, the less likely it might be to get to have someone come after you with a legal process.
Usually when a lot of times the three big debt buyers out there, should I say, is Portfolio Recovery, Midland Funding, and LVNV Funding. Those are the three big boys. If they end up selling it to them, then again they do have the ability to just file suit. If it's not sold to any one of those big three, there is many times it may get passed on to another collection company, then another collection company. Now legally, they're supposed to have all the documentation. Everything is electronic these days. Lots of times they do have it. So there's many times that they have the information, but obviously, when just like playing the telephone game, the more hands exchange, the more the odds are in your favor that they may not have everything required to prove the case that they actually own the debt, meaning the chain of command, as well as have all the documentation, such as the original contract.
So talk a little bit about the point that a consumer knows that they've got a legal problem. Because this is where it really gets serious.
Yeah, I've actually started seeing an increase in this. I've been doing this for over 18 years, and what happens is now they're going to do little trick tactics. Last night a client sent me a letter. It was from one of the three that I mentioned, and saying that, hey, this is currently in pre-legal status. Pre-legal status doesn't actually indicate anything, but for obvious reasons, if you owe money, things are tight, you're probably stressed out, and it's more of a playing on your emotions. Doesn't mean they can't do these things, but you're more vulnerable when you're like that. So if the moment you see something that says legal, it's natural for you to just sort of start having a little bit of a panic attack and going, oh my God, what am I going to do? What am I going to do? Well, at the end of the day, especially being in Texas, you're not going to jail. And there's debt buyers that actually, we call them zombie debt collectors, that threaten you, but that's a different story. But ultimately, if you get something that says this is the legal department, not pre-legal, but legal department, that's when you know you're probably about 45 days away from being sued.
Yeah, and that is clearly, I've always said, I don't want to know what your opinion on this is, though, but that is the goal, is to get out of that statute of limitations period and get on the other
Correct.
side of it without legal problems, and you have a lot more options. Would you agree?
Yeah, in the state of Texas, when you go delinquent on a debt, meaning the charge-off date that we were discussing, in Texas it's 4 years. A lot of states have an average of 4 years. There's a couple that have 3 years. There are some that actually have 10, which is mind-blowing to me.
Yeah, it
But
is.
yeah, you definitely, like I explained to my credit clients, when you have something that's under 4 years old, doesn't mean they're going to sue you, but the odds have increased that they're possibly going to, so you sort of have this dark cloud hanging over your head, and ultimately we have to have a conversation of, okay, is this something that we need to address? Or do you want to take your chances? My job, obviously, is always to provide the different options, in my opinion, and then obviously let them make their own decision.
Now, at the moment that you know you've got legal problems, what advantages could getting an attorney involved do for you? Because I know the statistics show that so oftentimes that you get into a legal situation over a debt that people don't show up. They don't even show up for the court date. They don't get any an attorney working for them. It would seem to me, and tell me what your opinion on this, but it would seem to me that if I'm a debt collector, am I going to spend the time and money to deal with someone who's got an attorney versus the other 98% who don't?
95% of the judgments that are filed, or should I say the lawsuits that are filed, go into the default judgment arena. So they automatically win right then and there. They don't even have, if you don't show up, most of the time they're going to then ask the judge to assess interest. I just had a client we're dealing with right now. He owed $6,500. He didn't show up to the lawsuit. He didn't file. He didn't do anything. The judge awarded $1,000+ in interest, $1,000 for attorney fees, plus other fees, where the bill is now $9,000 we're dealing with. So burying your head in the sand obviously is never a good thing, and it's not like TV where somebody walks up to you and says, "Hey, are you John Smith?" You say yes, they hand you paperwork saying you've been served. That's TV. That doesn't work that way. Obviously, every county is going to be different, but if you're sued, you need to respond. And even if it's simple as a letter that says, "I got the copy of the lawsuit, I'll show up when the judge says." You have to respond. If you don't, that's how you get the default judgment. If you respond, then you're telling that creditor, whether it's the original creditor or the debt collector or debt buyer, that you're probably planning on fighting this. Now, I've also seen people fight this, and something as small as a $3,000 lawsuit, the attorney firms fight like tooth and nail. So when you get sued, a lot of times you may get a solicitation in the mail saying, "Hey, we're the law firm of so-and-so, and there's a court filing that you've been sued." So they pay the courthouses for information on people that get sued, and saying, "Hey, we can help represent you, we can fight you in court, we'll help win the case." But unless it's one of those that have been passed over numerous times like we talked, they have the documentation, they have the proof, they have the contract that's been broken, you're going to lose. So now it's just, let's settle. So they're again, this is my opinion, of course, but you having an attorney represent you to whittle down or trying to settle the fee, you could do the same thing, or you can hire somebody that's not an attorney for cheaper to get those things done. But they're fighting it more and more, and then, of course, there's a bigger problem after the lawsuit.
This is Bob Brooks, and you are listening to the Prudent Money Radio Show. Today I'm talking to credit expert Wayne Sanford. And if you want more information about Wayne and some great resources, go to creditbureauinc.com. Let's talk a little bit about the process that this kind of the end game, where they get the judgment, and as you said, the vast majority of people get a default. I guess I'm saying that right, a default judgment. Talk about what happens after that, because when we used to talk about this years ago, and this was kind of the environment, is that they would go to all the trouble to get a judgment against you. And easily win it. Then it's just like they don't do anything. But that's not the case today, and this is what you got to be careful about. Talk a little bit about that.
Sure. So what happens is a judgment can actually stay on your sort of public record of sorts for 10 years. So a lot of times filing a lawsuit is their last-ditch effort to leverage the money that you owe them. And depending on numerous factors that only their company policy is going to deal with, they may say, you know what, we're just going to keep it on his file. He's got a lien against his name or her name. And eventually when they try to buy something such as real property, meaning a house, or possibly refinancing the house that they have or selling it, we're going to get paid because that lien supersedes the first lien position of a bank, meaning they get paid first. Now, if they don't want to do that and they want to be a little bit more aggressive, which I've seen a fair ramp up now, which is concerning for people, is they're now filing an additional document with the court, in essence really saying that, hey, we want to actively try to collect on this debt that we've legally won, and they're filing for what's called a receivership. A receivership basically means, and again, my standard, I'm not an attorney, don't play one on TV, but a receivership is hiring another attorney firm. So the attorney firm that represented the creditor or debt buyer then hires another attorney firm to go out, get the document from the court that says they're allowed to collect, and then go give it to your bank and freeze and take all your money. And I'm starting to see those filed a lot more. They're being filed more than I'm actually comfortable seeing. And my personal opinion is they think that maybe we're going to be going into a recession soon, so they're trying to take as much money from people as they can because they know they're not going to later. That part is, of course, just my opinion.
You know, I guess the overall recommendation is do whatever you have to do to stay current with your debts. Whatever you've got to do, whether you have to get an extra job, work extra hours, because that is when the dominoes start to fall, and that is something that's going to really follow you the rest of your life if you have a debt that keeps on showing up and with debt collectors.
Yeah, I mean, when I write a lot of blogs about these situations, and it's actually on my website, WayneTheCreditGuy.com, not the other one, but one thing I always tell people is if you don't know your rights, you don't have any rights. If you don't know your options, you have no options. So it's one of those you want to really find out what possible options you have, good or bad. If you don't know any, but now you have three, you may not like the three that you have, but at least now you know you have something rather than not knowing what to do.
Well, once you get a judgment awarded against you by a debt buyer, what steps can you take to make sure that you're protecting as much as possible? Now you're seeing them being a lot more aggressive after the judgment has been awarded, which does make sense, but that is definitely a shift in character. Is there anything that you can do that you can say, at least I can save this amount of money for my family? And obviously that's probably what's going through your head is how I'm going to take care of my family. Well, what kind of steps can you take?
Well, here's what I can tell you is when it comes to, let's say, whether it's you bank with 3 or 4 different banks, or you have one bank, if your name, like let's say several married couples have their own separate account, but they also have a joint account. So any account that has your name and Social Security number attached to it, they're legally allowed to take those funds. So if they wanted to protect themselves, ultimately they could remove their name from that because it's what your name's attached to now. Now, I'm not obviously saying here's how you hide your money. I'm just saying that this is what they're allowed to do and this is what they're not allowed to do. I know several business owners that transfer everything into their business name because if you own a business, your EIN is your business's Social Security number. So they're only allowed to take out the dollar amount, like if you owe $2,000 and you have $5,000 in an account, they're going to take the $2,000. They can't take any more than what the court said they can take. But they can only take it from your name with your Social Security number attached.
This is Bob Brooks, and you are listening to the Prudent Money Radio Show. If you want more information about Wayne, go to his website at, pull back up here, at the Credit Bureau creditbureauinc.com. Sorry about that, Wayne. And
okay.
you said the WayneTheCreditGuy.com. Did I get that right?
Yeah, that's sort of the joke is my nickname is Wayne the Credit Guy, so that just kind of became the marketing name. But the legal name of the company is Credit Bureau Investigations, yes.
So, one of the things that we talk about from time to time is, and this can be a really bad process to go through because it's scary, is debt collector harassment. And what most people don't know is that there is actually a really good set of laws passed in the 70s, I believe, that do protect the consumer from this type of harassment. But I got to think that this kind of harassment is really stepping up. I mean, I would think that debt buyers are getting really aggressive.
They're getting, I don't want to use the term a little bit more desperate, but I think they're being told that you need to be more aggressive than normal just because of the fact of what they're perceiving to happen down the line. Now, what I always tell everyone is just understand if it doesn't sound right, it's probably not right, but the Fair Debt Collection Practice Act and in the state of Texas, basically the Texas Finance Code literally says these things such as, they can't call you before 8 a.m. and they can't call you after 9 p.m. Now, if you're vacationing in California and you get a phone call at 6 a.m., well, it's not from where you're currently located. It's where you are, which is where you're living, which would be Central Time. For obvious reasons, they can't threaten to sue you because the collectors that you're talking to, they're not the ones that make those decisions. So if you have somebody that all of a sudden starts to threaten to sue you, if they say they're going to have you arrested, we're getting ready to file a document right now with the court suing you today by 5 o'clock at the end of the day, or anything of that nature, it's what we believe is a zombie debt collector, which is a debt that they probably don't own. They got your information. They know you owe the debt, and you may not even be legally required to pay it back from a statute standpoint, but they try to scare you. And I know a loan officer that got suckered on $700, and she knew better. But they just scared her so much, she got a gift, one of those debit cards, and paid them $700. So she got scammed, and she knows better.
Yeah, I've told this story before that I was on the program. In fact, the attorney I told you about earlier, Dean Malone, who used to, part of his practice was going after debt collectors and debt collector harassment. I did a program with him, came home, the phone rang, I answered it, and it was a debt collector. And they were wanting to know if my wife was home. And, of course, I immediately got into mode on the phone, and I was amazed at how much they pushed my buttons. And it was it was a debt in Kansas City. She'd never even been to Kansas City, so obviously it wasn't her debt. But it is amazing of how good they are. And I think it's safe to say is they're betting that you don't understand the laws or know that you do have protection.
Oh, without a doubt. I've even had some that I had, again, one of those zombie debt collectors tried to collect a 10-year-old debt from a friend and literally was threatening. It was from a car repo, the difference that he owed. And, again, they start off maybe really sweet, sort of lull you in, and then all of a sudden when things don't turn in the direction that they want, get super nasty and literally just scare you into the point where, again, they're manipulating your emotions.
So define harassment, though, because it is what there's a very fine line in what a debt collector can and cannot do.
Sure. If they hurt your feelings or say something you don't like, that's not really considered harassment. But if they're like calling on the hours of what we talked about before 8 a.m. and after 9, legally can't do it. If they're making back-to-back phone calls, they can't do that. If they use any sort of bad language or foul language, obviously that's against federal as well as state law. If you ask for some documentation, because you may not legitimately at that point in time remember what the bill's for, and they say, no, we're not providing you any of that, we're not required to, that's just a straight-up lie. So you would know that if they're making those sort of statements and not providing, like they want you to pay money on a debt that you don't remember, and they're not going to provide you any documentation, if something walks and talks like a duck, odds are it's a duck. But those are some of the main common things.
So what do you do, Wayne, as a consumer? Do you do you record? I think you can do this legally in Texas, but do you record telephone conversations? I mean, how do you gather the evidence so that you can protect yourself?
Sure. So in Texas is a one-party law, so you can actually start recording as long as one of the two parties knows, and if you know, then you're good to go. I do not know if cell phones allow you to record the call, to be able to record the actual call unless it's just listening to your voice. I know your typical VoIP phones actually have that call recording. Sometimes you get some collectors that are dumb enough to give you the ammunition you need via voicemail.
I know I've heard stories about that.
It's amazed. But ultimately, when they make these sort of claims, and like I said, if you can record it, then fantastic, because all that does is arm you with more information, because then the big joke is you could turn around and sue them for the money that they're suing you for, if it's in that state. But again, the one thing you have to realize is, okay, take a deep breath, because if you get one of those calls, you have to know that their job is to manipulate you, and they have been trained to do this. So you either have to step back, say, you know what, I'm not in a position to talk right now. Give me your name and number, and I'll call back. Hey, I don't recall this debt. Can you send me some documentation, and can we schedule a time to get back so we can talk? If they're fighting you on that, then you know that maybe they're either trying to push, because these debt collectors, they're like sales offices. They have an end-of-month quota.
Sure.
So they're going to try to get as much as they can. That's why a lot of times if you're going to try to settle some sort of a debt, the end of the month is always a great time, because they're trying to, like a sales office, get their numbers up.
Well, there's a lot to know, and with the way that there's as much debt that is out there, as aggressive as they are getting, you need to really know your options. Wayne, you can go to creditbureauinc.com or Wayne the Credit Guy. I'm assuming both websites are available with information. And the thing I like about what Wayne's doing is really about educating the people and getting people what their options are. And we'll have to have you back on the program to talk about. Well, there's a lot of things we can talk about, actually. But one of the things, I've got about 50 seconds, the pros and cons of sending a cease and desist letter.
They're good. What happens is a lot of people say, I want you to stop calling here or stop calling my work. They're allowed to keep calling unless, because they're going to claim that they never got it. But if you go to WayneTheCreditGuy.com and click on free downloads, there's a cease and desist letter that you should be able to download and then tweak, but you want to send that certified. After that, all they can do is contact you one more time to tell you what they're going to do. And then after that, if you wanted to file a small claims lawsuit against them for those violations, you could.
Wayne, great information. Once again, the website's creditbureauinc.com and WayneTheCreditGuy.com. And Wayne, thank you so much for being with us today.
Sounds great. Appreciate you.
This is Bob Brooks, and you are listening to the Prudent Money Radio Show. Thank you so much for joining me today. You know I do appreciate it. I'm going to have Wayne back on the program to talk. There's so many debt issues we can talk about, and really it comes down to getting educated about your options. And fortunately, you've got options that you may not have known that you actually have. So we'll have Wayne back on and talk a little bit about dealing with debt consolidation companies and credit card debt, and just all the things that are really a very big problem right now. So we'll talk about that at another time. This is Bob Brooks. If you have a question for me, please go to the website at prudentmoney.com and send it in, because we are all out of time. Till we do meet again next time, keep the faith and have a great rest of the day.
That's all the time we have for today. Questions or comments for Bob, or to find out more great information like what you've just heard, visit www.prudentmoney.com. Be sure to join Bob Brooks again for the next edition of Prudent Money.